now ready for agenda item number 24. This is the time and place for a public hearing to consider administrative civil liability order for Larry and Shireen Slate in Merced County. The designated parties for this proceeding are as follows: the board's prosecution team and the Slates. All other parties are considered interested parties. The prosecution team has a combined total of 20 minutes for direct testimony, cross-examination, and closing statement. The Slates also has a combined total of 20 minutes for the same. Interested persons shall limit their comments to 3 minutes. All persons expecting to testify, please stand at this time, raise your right hand, and take the following oath. Do you swear the testimony you're about to give is the truth? If so, answer I do. Thank you. This time, evidence should be introduced on the following issues: whether the board should issue, reject, or modify the proposed ACL. The order of this meeting is as follows. First of all, testimony by the prosecution team, followed by cross-examination, then testimony and cross-examination of the Slates, comments by other interested persons, and finally closing statement by the Slates, followed by a closing statement from the prosecution team. Please state your name, address, and affiliation, and whether you have taken, just a second, I missed the following issues. Okay, that's right. We have to swear in the witnesses, am I correct? No. Pardon? Doubly swear, yeah. Anyway.
Did you say swear at the witnesses? What did you say?
Very good. Please state your name, address, affiliation, whether you've taken the oath before testifying. If you haven't submitted a speaker card yet, now's the time to submit one to Ms. Rancho. Does Regional Board Advisory Team Council have any legal issues to discuss at this time?
No, I do not.
Are there any procedural issues that the designated parties would like to raise? Hearing none, we will proceed with the prosecution's testimony.
And Dr. Longley, again, before is Andrew Altivogt, Assistant Executive Officer. Before we begin, there are a couple things I just wanted to point out. One, I believe that the Slates are not present today. We had indication that they may not be able to make it. We'd hope they'd be able to make it, but they're not here. Given that, we just wanted, if we could have a little guidance, if you'd like us to run through our whole full presentation, if there's specific things, as in a lot of the factors and conditions in this case are pretty similar to the case that the settlement case that you heard earlier in the day. So we can do the full presentation. We can concentrate on specific things. We also have a penalty methodology spreadsheet that's available that we could put up on the screens at some point if the board desires.
You know, I would say we don't need to go through the whole presentation, except I'm concerned about board questions down the road. We may come back. So how long is your presentation? Let's do the 10 to 12 minutes.
Okay, and the only other thing I wanted to add is, since this is an ACL matter, I think the board has a lot of leeway in terms of changing findings, changing factors, and so we look forward to that input, of course. Thank you.
Thank you very much.
Good afternoon, Chair Longley and members of the board. My name is Dana Kalesha, and I work in the Irrigated Lands Regulatory Program. I have taken the oath. The item before you is a proposed administrative civil liability order for Larry W. and Shireen I. Slate of Merced County. The ACL complaint was prepared for a failure to obtain regulatory coverage for discharges of waste to waters of the state from a commercial irrigated agricultural operation. Settlement negotiations occurred in the Davis case, which you heard prior to this one, which led to a stipulated order. Slate did not enter into settlement negotiations, so this case is a proposed ACL order. This is the same background information that was given in the Davis Trust item on the Eastern San Joaquin River Watershed Order. I'll go ahead and skip it unless you'd like to hear it again.
Flip through it.
Go through it? Okay,
Pardon?
skip it, flip
Skip
through
it, yes.
Water Board staff used publicly available information such as county tax assessor rolls and satellite imagery to identify likely owners of commercial irrigated lands. These figures show the location of the 5 eastern Merced County parcels totaling about 110 acres that are named in the complaint. This table lists the 6 parcels associated with the Slate case. In addition to the 5 parcels named in the complaint, Slate included a parcel as part of his operation on the ENOI with a different owner. This parcel is shaded blue in the table. One of the parcels included in the complaint is listed in the 2014-15 Merced County Assessor's Roll as owned by Larry Wayne and Carrie Slate. This parcel is shaded brown in the table. It is not known if this is the same Larry W. named in the complaint. About half of this parcel contains orchard trees, which is about an acre, acre and a half, and the other half is a home. During the open enrollment period, Water Board staff sent 2 notification letters to Slate which explained the new regulations, coverage options, and the open enrollment period. These letters were sent in February and April 2013. Since Slate did not respond to either of the notices by contacting staff or obtaining regulatory coverage, staff conducted inspections of the Slate parcels in September 2013 and found commercial-scale irrigated almond orchards. This is a photo from the inspection. In October 2013, the Assistant Executive Officer issued a Water Code Section 13260 directive letter to Slate. The directive required Slate to obtain regulatory coverage for their irrigated agricultural land within 15 calendar days of receipt of the directive. Slate could comply by joining the East San Joaquin Water Quality Coalition or by submitting a report of waste discharge. The certified mail receipt for the directive was signed as received by Slate. However, Slate did not respond. A notice of violation was therefore sent in November. Again, Slate signed the certified mail receipt and did not respond.
You say signed but did not respond. Is that correct?
Correct.
Thank you.
In January 2014, staff sent Slate a notification letter, otherwise known as the pre-ACL letter, that an administrative civil liability for $3,080 would be issued if Slate did not get regulatory coverage and initiate settlement discussions. The certified mail pre-ACL letter went unclaimed by Slate and was returned to us in February. In May, the Assistant Executive Officer issued an ACL complaint to Slate. The proposed penalty was calculated to account for the size of Slate's farming operation, utilizing the enforcement policy's other factors as justice may require. Slate's farm was estimated at 110 acres, so the Assistant Executive Officer elected to impose a penalty of $3,080, which represents $10 per acre plus $2,000. Slate signed the certified mail receipt for the complaint. In June, Slate contacted Water Board staff. After hearing an explanation of the Irrigated Lands Program and its requirements, Slate indicated that he did not intend to join a coalition or enroll under the individual general order. Board staff advised Slate to read the complaint carefully and respond with one of the options described in the complaint. In July, the advisory team issued a memo tentatively rejecting the proposed settlement agreements for 2 irrigated lands enforcement cases similar to the Slate case. The advisory team requested further explanation on how the proposed settlements adequately address the board's regulatory interests. It also stated that the proposed penalties might not be sufficient to deter recalcitrant growers and that the particular method used to base the penalty on farm acreage may not be appropriate. It recommended either a modified penalty calculation method or further justification for the method used. On July 17th, the Assistant Executive Officer rescinded the Slate ACL complaint in order to address issues raised in the advisory team memo. The prosecution team concluded that these issues also applied to the Slate enforcement case. The prosecution team revised the penalty methodology and expanded the explanation in response to the advisory team memo. The revised proposed penalty was calculated using the enforcement policy's steps 3 through 6, which include the alternate approach for multiple day violations and adjustment factors. I will review these on the next slides. The economic benefit for the Slate case was revised to be based on the estimated costs to comply with the individual grower general order. Because at the time the ACL complaint was issued, Slate had not obtained regulatory coverage and had stated to staff that he did not intend to join the coalition. In contrast, Davis's economic benefit was calculated based on the estimated costs of participating in the coalition group, because Davis had already joined the coalition group when the stipulated order was prepared. The prosecution team proposes that the potential for harm for this non-discharge violation is moderate and the deviation from the requirement is major. Slate disregarded the regulatory requirements. The orders adopted by the board specify the expectations and requirements for water quality protection, which do not apply until the discharger is covered by an appropriate order. The requirements in the applicable orders are rendered ineffective when a discharger has not gone through the process of becoming subject to the order. Slate was given a culpability score of 1.3 and a cooperation score of 1.1. Board staff sent 2 notices, a 13260 directive order, an NOV, a pre-ACL letter, an ACL complaint, and a revised ACL complaint before Slate obtained regulatory coverage. The multiple notices and failure to respond suggest Slate acted intentionally in ignoring the requirement. Cleanup is not applicable here. Following the enforcement policy's guidelines, the total violation days were reduced from 323 to 16. The prosecution team finds this to be appropriate because there is no evidence that Slate's failure to get regulatory coverage caused daily detrimental impacts to the environment or to the regulatory program, since obtaining regulatory coverage does not result in an immediate evaluation of or changes in practices that could be impacting water quality. There was no daily detrimental impact to the regulatory program because information that would have been provided by Slate pursuant to the regulatory requirements would have been provided on an intermittent rather than daily basis. Moreover, Slate's failure to timely enroll in the program resulted in no economic benefit that could be measured in a daily basis. The maximum initial liability for 323 days of noncompliance is $323,000. The minimum liability is the estimated economic benefit plus 10%, which is approximately $5,650. On September 12th, the Assistant Executive Officer issued an ACL complaint to Slate with a proposed penalty amount of $9,152. The certified mail receipt shows Slate received and signed for the complaint. After the complaint was prepared, some new information became available. In October, Slate came into compliance by joining the coalition group and submitting an ENOI to the Water Board. Evidence items 20 and 21 document this new development. Additionally, staff recently discovered evidence that Slate received the 2013 NOV. Due to a filing oversight, the signed certified mail receipt for the NOV was not previously available. This new fact supports the prosecution team's case, since it is evidence that Slate received one more notice from the board than previously thought. Between February 2013 and October 2014, staff sent 6 letters and had 2 phone conversations with Slate before Slate enrolled in the coalition. Almost 5,000 landowners received outreach letters in the eastern San Joaquin River watershed area, and over 2,000 enrolled with the coalition. The prosecution team proposes that the advisory team's concerns have been addressed. There is more explanation on how the penalty was calculated, the method used was refined, and the amount is substantial, which should serve as a deterrent. Slate ultimately came into compliance by obtaining regulatory coverage. The prosecution team recommends that the board adopt the proposed ACL order. This concludes my presentation, which I would like to enter into the record along with the agenda materials. Members of the prosecution team are available to answer your questions. Thank you.
Thank you very much. Any questions? Or is everybody wore out?
Dr. Longley, in terms of the advisory, I just want to make the record clear. We never sent a letter rejecting anything regarding this ACL to the advisory team. I mean, to the prosecution team. They may have done it voluntarily, but I've never sent, at least on behalf of the board, anything asking them that they pull it or reject it, or asking questions about the ACL itself.
Right, but this one is different than the previous one because there's been
It
no
is,
settlement.
but they allege that
no
we
settlement on this one.
They allege that the advisory team rejected the settlement of this particular complaint. In a letter and included in their evidence on 11 July 2014 letter, we did not reject the Slate ACL. It was a William Sinks ACL that was rejected by the prosecution team.
Sure, and I'm sorry if there was a misunderstanding. We agree with that. We pulled this one voluntarily based on the guidance that was given for those other two.
I
So-
think in the record they said the
Okay.
advisory team, and
All right, no, we agree that this one was one that
So
we
the
pulled
prosecution
voluntarily.
team's record should read that they are the ones that pulled it.
Yes, that's
prosecution
correct.
team
Thank you.
pulled this.
Okay, we must make sure the record correctly records that fact. Is there any discussion? Hearing none, then, thank you very much. I just want to make sure, is there anybody here representing the Slates? I don't see anybody but that doesn't mean that there may not be somebody here. Attorneys are known to go look for clients, who knows? They are not here, that's been confirmed. So there's no way that they can cross-examine or provide testimony. Are there any interested persons wishing to provide testimony? Seeing none, and the Slates are not here to provide a closing statement, I'll simply take a closing statement by the prosecution team.
Sure. Thank you, Dr. Longley. And again, as with the prior case that you heard today, I mean, we really are looking for guidance from the board. We understand that given some of the discussion that happened in the Davis case prior to this, and the fact that we used a lot of the same methodology and factors in this one, that there may be things that the board would like to alter for this case, given that this one is an ACL. I believe that that's something that certainly we'd be open to based on guidance from the board, and if there are particular findings that might need to be changed to support that, we could certainly help to do that, and we're certainly willing to answer any questions that you may have that may help to clarify some of the things that are in this particular ACL.
My own concerns are that, it appears that this is almost cost of doing business in their eyes. And they have obviously ignored the board and at the last possible minute attempted to throw the towel in. I think, unfortunately, this is, unless we send a good, clear message, we're going to see this time after time after time. And I think this board has to go on record that this is unacceptable, and if this is the direction you want to go, then you're going to have to pay a monetary penalty for making that decision. And that, quite frankly, will make a more level playing field out there, if you will, for all of those thousands of people that have already stepped up and paid their money and joined the coalition and have been tried to be part of this program. This is an element that is very defiant. And there's a lot of people out there that think we just should go away and leave them alone and let business go on, let them make their, in some of the cases I've seen where they're growing almonds, unbelievable profits. So, that's, to me, as one board member, that is completely unacceptable. And I think we have to, within the laws, within what we can do, obviously, that we have to find ways to send that message. I'd like to see this penalty raised. And just one small point, it goes back to that one factor the daily factor. I think that daily factor should be 0.7. That's one start. All the days have been collapsed to 16. Why 16 days? I mean, this is a very severe violation. They're thumbing their nose at us. And there's a lot of others out there thumbing their noses, showing up at the coffee shop in the morning, bragging about why in the hell are you paying your money to the regional board or to the coalition in this case. I'm not doing it. Look. So I think that's the message that has to be sent. And that's doing a service to those people who are actually part of the program. If you will remember, we had testimony provided here by members of the board of the East San Joaquin Coalition, not too many board meetings back, and we had growers who are members of that board asking that we do something to make a level playing field. So that's what I'm looking for. Okay, I'm sorry, I'll get off my pedestal. Yes, Bob.
Did you have a motion?
Well, I think that there could be a motion, but I'd like to say a few things first. One of them is a question. When we go here to the economic benefit calculation, I don't see how that. So let me make sure I'm looking at page 46 of the item, where it says economic benefit 5136. The top of page 47 talks about the fees to join 3,400, the cost of preparing a plan 2,500, groundwater monitoring 4,650, and so these fees seem to be a lot that's been avoided. Why are we at 5,300? Okay, am I misreading it?
Well, I think I may get back to what Patrick was talking about on the previous item. And if you would follow the stormwater example where you don't have to build infrastructure, where you don't build infrastructure purposely, those are costs that you're avoiding.
So I'm sorry. Could you? I'm just finding where you are
Sure,
now.
okay.
So, so one of the questions I think. Do we have Jerry Horner here still? Or,
Yes.
So, so one of the questions is about the permit fees.
Well, my
right?
question is the economic benefit calculated based on them joining the coalition or them going on their own?
It's based on their going on their own under
Okay.
an individual order. So things like the permit fee, there's that ends up being an avoided cost,
Right.
because if you don't join in 2013, then you haven't paid, and the state doesn't go back and say you should have paid that.
So I'd just like to say for the record that this is how I'd like to see the economic benefit calculated for all ACLs, irregardless of whether they're planning on joining coalitions or not. So this is the correct way, and this is how I'd like to see all the ILRP ACLs. So I want to thank you for that. I think it was done. I think it was done well. Chairman Longmeatley has mentioned that he'd like to talk about the days, and that's something I'm open to. But I'd like to say that the economic benefit calculated here is good, and I like that.
So once again, we had 330 days, I think it was, as the maximum, if I'm not mistaken, something like that. But it was collapsed to 16 days. What other options do we have?
This is Andrew Tarianen with the Office of Enforcement for the prosecution team. As we discussed during the Davis hearing, there's discretion to go above the minimum number of days, which is what the enforcement policy methodology gets to. Again, in this case, we didn't make any findings that something higher than 16 days was necessary, but that's well within the board's discretion
Well,
here.
16 days is infinitesimally small compared to the total days here. So it's what, 5%? Roughly, yeah. So I would simply double that, and we're still only about 10% of the maximum days. I'd go to 32 days, and I would use the 0.7 factor, and that would be my calculation, plus the other factors that are in there. And I concur with Vice Chair Moffett regarding the economic benefit. Thank you.
I agree too.
And Dr. Longley, can I ask? We do have that methodology spreadsheet available. If the board that we can bring up on the screen, if the board would like to see that, it might take us a couple minutes to get it.
Let's do that.
Before we do that, can I ask that we do have our state economist here, and I think that we would like to make a statement regarding the comments on economic benefit.
Okay,
If that's-
Jerry, did you take the oath? You want to come forward, please? Raise your right hand, please. Do you swear what you're about to say is the truth? If so, answer I do. Thank you. The mic's not on.
Mr. Chairman, members of the board, my name is Gerald Horner, economist, State Water Resources Control Board. I'm here as one of my last official acts as an employee. I am retired. The remarks on the compliance or the delayed versus avoided. Since we have been doing the economic benefits of noncompliance, we've used the Ben model, okay? And the Ben model gives us guidance in how we make decisions regarding the delayed and avoided. And the action is delayed if, in fact, they have agreed or have complied with the action at the date of the analysis. And if you look at this analysis, stand up. It was done December 2nd, 2014. And I simply inquired of staff, had they complied or have they not complied? And in this case, they said they had not complied. So therefore, it is an avoided action. But the other action previous to this, the Davis Trust, that was not the case. They had agreed to comply or they had complied. So that is the sole determinant of whether it is delayed or it's an avoided action. Questions?
So, yes, and so I'd like to ask a question of the board. If you disagree with what has just been stated as the process that has been used regarding the Ben model, whereas when the date that analysis is run, if they have complied, that is one factor, that is lower, that's an avoided, what's the word? That's a delayed cost, but it's an avoided cost, which is higher if they have not complied as of that date. Is there an issue with that? Insofar, that's what has been going on. We've been told. Are we in concurrence with that as we go down the road?
I would add. I think Mr. Horner's hitting the nail on the head. What it really depends on is what day you run the analysis, and when do you consider the economic benefit of when the discharger is in or out of compliance. Is it the day they're caught, or is it after they've tried their best to rectify the situation? And that is something that there's a lot of room for interpretation on, and that's something that the board doesn't have a whole lot of hard and fast guidance about how that initial date is done.
But that's not really what I think I'm hearing, Patrick. It's when he runs the analysis, not necessarily the date that you would use if they're caught.
Well, even the prior item, and I hesitate to talk too much about it, but in enforcement cases in general, the date that he enters into the equation is really the date that's most important. That is sometimes the day that they run the analysis. That's sometimes dated to the date that the business decision is made. A lot of thought and interpretation can go into the dates that are picked. I certainly have absolutely no difference of opinion with what the economist is saying with respect to what is and isn't a delayed and avoided cost when you, at the day that you do that analysis. But picking that day is a really critical issue.
Yeah, I agree. I mean, that means we could be running analysis up to the day of our hearing. And, you know, in this case, for instance, they have since
Right.
joined the coalition, and so it can make it very wishy-washy. I think if we follow the procedure that you do at the day that they are caught, then it doesn't, you know, you don't penalize someone for taking an extra 2 months versus someone who went a little earlier, and they should be penalized in that way. But I think it's the day that, as far as I'm concerned, it should be the day that they are caught, because otherwise you're just encouraging people to retroactively be able to try to cover up their
No.
mess.
If I say the day they are caught, are you meaning the date of the NOV?
It would be the first date that they were out of compliance. So it would be the date in 2013 that they did not choose to join the coalition, and that was the deadline by which they were supposed to have joined the coalition or be in the individual order.
And I think I'm not the one to answer those particular questions. I think in terms of talking about how that date is selected, I defer to the prosecution team and certainly the economist about whether it would be reasonable to select as an economic benefit of noncompliance to set that date at the date that the discharger is at the date that they have to pay their fees to the coalition, or potentially the day that the that the board discovers that they've been cruising along without paying the fees, and the day that they receive that notice of violation or the civil liability complaint.
So with that said, we'd like advice from both the prosecution team and, of course, Mr. Horner.
So maybe if I could start, Dr. Long. I think one of the things that we may see, and I don't really know exactly how this will play out, but if you start it earlier, there's the potential that, you know, given the facts of the case, that it could in fact be lower. Like if there's some requirements that if it was when the ACL was issued, or there were some meetings that they were supposed to go to that would have otherwise entered into this equation, or there were other requirements that they would have avoided in that intervening time, then perhaps by doing it earlier, it could in fact be lower. And so I just want to make sure that that's also clear. And there, and again, we do try our best to figure out what works for each case in this regard, but we certainly appreciate the guidance on how best the board would like us to do that.
And can I follow up just briefly? Typically, and what we did here, the date of the calculation, so when Jerry says the day he runs his analysis, we try to be more or less contemporaneous with the issuance of the complaint. So here the complaint was issued about the 12th, and the analysis was run the prior week or so before. And that's our usual practice, which I think is what resulted in some of the problems that we saw in the confusion about Davis, because the complaint was a few months before, and then we started settlement, which changed things a little. But in the ACL complaint process, we try and have the calculation, which includes the multi-day violation calculation, all the relevant calculations for the enforcement policy methodology, be roughly contemporaneous with the issuance.
You're talking about the NOV?
No, the complaint.
Oh, the complaint.
Yeah, and in this case, the complaint was issued in September,
Okay.
September 12th. The beginning of the violations period was the date that in this case, that the enrollment was due. Yeah, 15 days after the directive letter was issued. So that would be the beginning of the spreadsheet that Jerry prepared. The end of it, which is the date of his analysis, which sort of, boxes in the actual violations period, is roughly when the complaint is issued. We try and make it almost the same day.
Well,
if we can.
I'd like to see us agree upon a date, and obviously, each case has its own merits. I'd like to see that process be open-ended so that if there is reason for an exception, then obviously we would expect you to fully justify that exception, but leave it open-ended. Yes, Carmen, I'm sorry.
Would we be interested in maybe deciding that the calculation would be based on the date they are out of compliance or the date that the complaint was issued, whichever is greater? Could we do something like that?
We would not want to set policy like that in this type of setting. And frankly, it's often the case, as I've mentioned before, in a spill context, where if you have a massive spill because you didn't spend, $10,000 to install the proper valve, by the time the notice of violation is issued, the discharger could have spent $40, $50, $60, $100,000 to rectify the spill that was caused by their lax investment in pollution control technology. So fixing a date for conducting an economic benefit analysis is far more an art than it is a science, and so we wouldn't want to lay down hard and fast rules. I think for the purposes of this ACL, it's worth inquiring, as it was in other ACLs, when that date was picked and what's the rationale for picking that date. Because when you pick that date, it's very important, particularly because many of the dischargers in our irrigated lands program will pay their fees to a coalition at one point. And very often those coalitions charge an extra fee if you're paying those late. So in that case, if we were to include that in our calculations as a matter of course, the economic benefit really would never really be factored into these, which may be appropriate. It could be something that could be considered as a factor that other factors as justice may require, but it would factor a little less into the economic benefit calculation, because essentially whenever you're paying late fees plus your past due fees to a coalition, you wouldn't really be having an economic benefit for noncompliance. But again, there may be an extra cost for getting caught with it and not paying until you get caught. That's a slightly different inquiry.
I was really addressing Patrick, and I don't think we're that far off. I'm being told that they generally do it around the date of the complaint, and they said, I heard the word normally, and so I was suggesting this be an open-ended process where the board understands that that's the date, and at some other date there be ample justification for that.
And there's certainly room to, and I think Gerald Horner or his successor, whoever that may be, we'll have
I saw a hand over here.
I'd like to take this opportunity, if it's Mr. Chairman, to introduce my successor, Dr. Madeline Ransom. She started the 1st of November, and I've spent the last month with her, and she already knows a lot more than I do, so I'm sure she'll be able to give you guidance that I certainly can. I just want to...
Thank you, Dr. Ransom.
I just want to make something clear. The Ben model is not to provide a deterrence, okay? That's not what Ben is for. Ben is to calculate what the economic benefit of noncompliance, okay? The deterrence part of the ACL is done in steps 1 through 5 of your penalty calculator. So if you're concerned with deterrence, that's where your concern should go. But I think you want the Ben model and the Ben analysis and the Ben results to be as clean as you possibly can, and that you can explain it in very, very simple terms and not have a lot of footnotes on the end of the table. So that's my recommendation.
Thank you.
And I frankly, I think for situations where you do have set fees and you have a very good idea about what's going into that situation, getting a defensible economic benefit, and even if it is relatively small, often leads to more defensible orders. But you have to essentially justify your increases not on an economic benefit basis, but more on these are the wrong actions. These are the bad, kind of avoidance issues that you did as part of your lack of compliance. Sometimes that makes the other factors, as justice may require, a little more sophisticated.
I think we can probably pursue all of this more when we have the information item on how we go about developing penalties and so forth in this process. Look at some of the policy issues at this time. I'd like to get through with this, with the Slade issue. I don't believe in setting, tell me if I'm wrong, but I don't believe in setting this, the penalty in this particular case, that it hinges much on the economic benefit.
I would agree. We've got a defensible number of about $5,000 as an economic benefit.
That's right, and I think that number should be higher. And I explained that previously, and that takes us back to the 60 days. That's, we were talking, 32
and by
days.
By that number, it's the administrative civil liability number, not the economic benefit.
Exactly, and that brings us back to the 32 days, and then Mr. Horner started giving us his wise advice, and we went down that road for a while, but I'd like to come back to the 32 days.
If there's 32 days, I get $18,304.
And I'd like to see the 0.7 as in these kinds of cases as a general rule. So we were going to put up you have the spreadsheet up. Yeah. And
It'll take us just a minute to make sure we have all the correct numbers in there for everything else. But
okay, so why don't we start with the other one?
I think very often it's tempting to play with the calculator. If we're set on a couple numbers, I would actually counsel the board to let's set on those numbers and have the prosecution team craft findings to make that work, as opposed to toying with the calculator, particularly when there's a discharger that's not here.
I think you're right, and I think as general policy on these kinds of cases, we need to go to 0.7 rather than 0.4 on the day factor. And in this case, and I think in general, rather than the minimum number of days, which is about 5% roughly in this case and in the previous case, we need to go closer to 10%, which in this case would be 32 days.
It sounds like a motion.
So, yes, so I'll make that into a motion. I move that the ACL amount for this, certainly on the day factor, this is very significant action and a defiant action on the part of the discharger. I think that number should then be moved to 0.7. Specifically in that particular chart, it would be the moderate column and the major row, R-O-W. And yes, the deviation from the requirement is certainly major in my mind. The potential for harm is moderate, but I would put it at the top of that column, and that would give us a 0.7. I think to assess the minimum days moves us away from, there's a great potential for harm here. And by choosing 16 days, we're saying, that really wasn't that much potential for harm. I think 32 days is more appropriate to show that there is potential for harm. So, what is that amount? $32? So, if that is the amount and I'll let them run it, I have no reason to.
And I say that with difference to Patrick's about not running the calculators, but it is important when you get down to other factors that justice may require to know kind of
Right.
a ballpark.
And so I'll make the motion that we increase that ACL be in the amount of $32,032 for the reasons I have previously cited, and in compliance with the findings that were provided by the prosecution team, with the exception, I think there is much more threat to the environment than was encompassed in the prosecution team's calculation. And as other factors may require for justice, I think that is also required. Thank you. That's my motion.
Well, I think with all that said, it might be worthwhile to get some language in front of the board, to essentially have an administrative civil liability order with those numbers in it.
How long it's going to take you to do that language?
Prosecution team has the documents. You could propose an order.
Normally, advisory council prepares the order based on the board's findings as read from the bench. I would be happy to bring the Word document to you and help you craft the
I'm
findings.
inviting you to put 0.7 and double the number of days and see if you can send that my way.
Okay. Yeah,
And we can have
15 or 20 minutes.
Well, I'm going to give you 5 after 3. We'll take a recess till 5 after 3. Yes. I'll tell you what. I think Bob made a good suggestion. Let's continue that, and you folks can go do what you have to do. And we're going to go to the next item and start the next item. We'll bring that item back at the end of the next item. It is getting late. People are sitting here. We are now on agenda item 25. This is a time and place for a public hearing to consider administrative civil liability order for the California Sprouts in Sacramento County. The designated
Dr.
parties for
Longley,
the, yes.
we might need a few minutes to just kind of switch chairs because Patrick serves on the advisory team for the matter that's been recessed, and I serve on the advisory team for the matter the board's going to be currently considering, and I'd like to be with the advisory team on the end of the room, if that's all right.
You'd like to be in the other room?
I'd like to be sitting right where Patrick
over
is
here.
sitting.
Okay, well,
Thank you.
I'll start over again. I'll give you about 3 minutes to change places. This and I'm there. Now you push. Let me get it on.
You see
I'll restart. This is agenda item 25. This is the time and place for a public hearing to consider an administrative civil liability for the California Sprouts in Sacramento County. The designated parties for this proceeding are as follows: the board's prosecution team and California Sprouts. All other parties are considered interested persons. The prosecution team has a combined total of 30 minutes for direct testimony, cross-examination, and closing statement. California Sprouts also has a combined total of 30 minutes for the same. Interested persons shall limit their comments to 3 minutes. All persons expecting to testify, please stand at this time, raise your right hand, and take the following oath. Do you swear the testimony you're about to give is the truth? If so, answer, I do. Thank you very much. This time, evidence should be introduced on the following issues: whether the board should issue, reject, or modify the proposed ACL order. The order of this hearing is as follows: testimony by the prosecution team, followed by cross-examination and testimony and cross-examination of California Sprouts. Next, we'll have comments by interested parties. Finally, closing statement by California Sprouts, followed by a closing statement from the prosecution team. Please state your name, address, affiliation, and whether you've taken the oath before testifying. If you haven't submitted a speaker card yet, now is the time to submit one to Ms. Lanfranchi-Vizzardi. Does Regional Board Advisory Team Council have any legal issues to discuss at this time?
Not at this time.
Thank you. Are there any procedural issues that the designated parties would like to raise? Seeing none, we will proceed with the prosecution testimony.
Good afternoon, Mr. Chair and members of the board. My name is Wendy Wiles. I'm an environmental program manager here in the Sacramento office, and I've taken the oath. We're here today to ask that you assess mandatory minimum penalties for California Sprouts because they failed to submit the monitoring reports required by their NPDES permit. This is a different type of penalty than what you were just listening to in the last two ACL cases. This is a mandatory penalty. It's not discretionary, and therefore we don't use the penalty calculation method, and we don't look at an economic benefit or anything like that. Before I really get into the presentation, Andrew Altavogt would like to say a few words.
Dr. Longley, members of the board, Andrew Altavogt, Assistant Executive Officer, and I have taken the oath. So before we begin with the formal presentation, I wanted to just highlight a few things, a couple of which Ms. Wiles has mentioned. I think most of the ACLs that you see before you, the ones that you've considered today, have been discretionary in nature and involved using the enforcement policy and methodology in determining penalty amounts. This ACL that's currently before you is a mandatory minimum penalty, and what this means is that the water code sets a minimum penalty, and there really isn't much discretion for staff in determining what that minimum is. And the second thing I wanted to really highlight is we understand as the prosecution team that if this had been a discretionary enforcement action, the penalty would likely be a lot lower than what's being proposed. And frankly, we've looked into ways of reducing this penalty, some of which have been presented in materials, the Dischargers Council. But given the stringency of the statutes, we couldn't legally reduce it. And frankly, I've had several discussions. I've had extensive discussions with our attorney, Ms. Drabant, as well as several of the other attorneys in the Office of Enforcement, including Chris Kerrigan, the head of the Office of Enforcement, who've all advised me that they could not legally support a lower penalty given the stringency of the statute and the facts of this case. So, we're open to a lower penalty, but we couldn't make the determinations that would allow us to do that given what the statute tells us. So Ms. Drabran will address some of these particulars in her part of the presentation.
I suspect from what I've seen that the counsel for the discharger will present testimony contrary to what you're saying, but go ahead with the testimony, please.
California Sprouts grows different varieties of sprouts in an indoor facility. Wastewater is discharged to the City of Sacramento storm drain, which then goes to Morrison Creek and then the Sacramento River. For 20 years, the discharge from California Sprouts was regulated by an individual NPDES permit. As part of that permit, California Sprouts was required to submit quarterly and annual monitoring reports. The reports were generally submitted on time, although in 2010 we had to send a notice of violation because of 4 missing monitoring reports. The notice of violation clearly states that the Water Code requires that we assess mandatory minimum penalties for late reports. In 2012, the board's permitting staff determined that California Sprouts could be regulated under the NPDES Limited Threat General Order instead of under an individual order. The discharger applied for coverage under the general order, and on June 7, 2012, the board rescinded the individual WDRs, and the discharge from California Sprouts began to be regulated by the Limited Threat General Order. The notice of applicability for the general order states that monitoring reports are due on a quarterly basis, beginning with the third quarter of 2012, and that failure to submit the reports will result in mandatory minimum penalties. There are other dischargers from our office who have transitioned from being regulated under an individual NPDES permit to being regulated under a general order, and they have been able to successfully submit the monitoring reports required by the general order. But that's not the case with California Sprouts. Despite having submitted quarterly reports under its individual permit, and despite the directions in the notice of applicability, California Sprouts did not submit 7 quarterly monitoring reports on time. It was only after a reminder from the board that these reports were submitted in June of this year. The Water Code requires that we assess mandatory minimum penalties when there's a discharge to surface water and a monitoring report is submitted 30 days late. California Sprouts agrees that there were discharges to surface water during this time period, that the reports were submitted late, and that MMPs must be assessed. But the reason that we're here now is that there's a legal disagreement over how to interpret the Water Code and how much the mandatory penalty must be. The prosecution team's attorney's interpretation is that the penalty amount is $210,000, while California Sprouts' attorney's interpretation is the penalty amount is $30,000. There's no interpretation of the Water Code for any amount in between these two amounts. It's $210,000 or $30,000. Laura Drabant, our Office of Enforcement Attorney, will now discuss the legal aspects of the case.
Good afternoon. I'd like to first start with an overview of the general rule applicable in this case for MMPs. Section 13385.1A1 is what I'm referring to, and please note you have the entire code section in your exhibits, number 55. What I have before you on the slides it's a truncated version. The general rule is that failing to file a discharge monitoring report for each complete period of 30 days is considered a serious violation. And each serious violation is worthy of a $3,000 MMP. And so the amount assessed in the complaint comes to $210,000. For a time period, there was an exception to the rule, and that was an MMP could be assessed for each report not timely filed, but only one $3,000 MMP per report. And this is if 2 conditions are met, and that would be the discharger did not receive any notice of the obligation to file its quarterly reports, and that the discharger did not violate any effluent limits during those time periods. And this exception was in effect from January 1st, 2011 through January 1st, 2014. Even if the exception could be retroactively applied after it has sunsetted, the discharger does not qualify for the exception because it had more than sufficient notice. So let's take a look at the notice condition. The parties agree that no complaint or NOV were issued in this case. That's the first possibility of notice here. 2 NOVs were issued related to violations of the individual NPDES permit that expired before the general low threat permit took effect, but no NOV was issued specifically to this general order. That leaves us with whether the discharger had notice of its obligation to file quarterly discharge monitoring reports. And the rebuttal brief outlines 8 specific written notices to the discharger about permit requirements, including emails prior to permit coverage, process of issuing a new limited threat general order and hearings related to it. And there was also revisions to the new limited threat general order and hearings related to it. All that occurred during the time of the coverage was under this permit. But I'd also like to emphasize that the discharger had actual notice of its obligations to file quarterly reports. The rebuttal brief explains that Mr. Dan Schall, the general manager of California Sprouts, had actual notice of the obligations since 2012. He admitted that he lost track of the responsibility to follow up with the board staff and failed to send in written copies of the reports. So, legally speaking, the notice condition for the exception was not met because the discharger had ample written notice of its obligations under the permit and had actual notice since 2012 that it was to submit quarterly reports to the water board. So the prosecution is taking the position that we cannot legally apply the exception to the general rule for these MMPs. But if we could assess the MMPs differently, we would have. And again, as I touched upon briefly earlier, the exception is no longer in effect in the law because it has sunsetted. So if the board reaches a different conclusion about whether or not the discharger had ample notice of its obligations under the permit, it still needs to decide whether the statute allowing the reduced penalty assessment that's sunset at the beginning of this year, whether it can be applied retroactively to violations occurring before the exception sunsetted. So in general, the two contentious issues for the board to make a decision about today to apply the exception is whether the discharger had notice of its obligations and whether the statute still applies even though it no longer exists in law. So my legal summary is that the exception does not apply because they had ample written notice and actual notice back in 2012. The provision has sunset. And again, this is a mandatory minimum penalty. We don't have any factors to consider. And so running the math, it comes to a $210,000 penalty. If the board would like to agree what it hears from the discharger and issue a penalty of $30,000, the board must find that no notice of obligation, that the discharger did not receive any notice of obligation to submit its reports, and that the statute still applies even though it's sunset and is no longer effectively on the books. Now, to find that the statute still applies, there's an analysis in both the discharger's letter and in the rebuttal brief. But to summarize it here, the board would have to find that the statute was substantial in nature and not procedural, that the statute was retrospective and not forward-looking, and that the facts in the case before you are more consistent with the case as you sow and dissimilar from the case Rio Linda Union School District. So the conditions in 13385.1b for the exception were not met. Therefore, we may not apply the exception. 13385.1b is no longer effective. Therefore, we may not apply the exception. We then must resort back to the general rule that I started my portion of this presentation with, and that every 30-day late period for a report is a serious violation to be assigned a $3,000 penalty. And therefore, the board is obligated to issue liability in the amount of $210,000.
Counsel, if I could ask you a question quickly.
Certainly.
As you know, under the law, there's different kind of notice. There's legal notice, constructive notice, but then there's also different kind of notice. So, you know, someone who knows about a lawsuit and isn't served with the lawsuit isn't necessarily charged with the obligation to appear or defend. So does the code section say what kind of notice is sufficient to meet the threshold here in the law that you cited?
It's all in how you interpret it. It doesn't say actual notice. It doesn't say procedural notice. None of the standard legal terms. So again, it's Exhibit 55 if you want to look at the actual language of it. It gives the two examples of the NOV and the complaint. That's very clearly stated. But then it talks about notice of obligation under the permit. And so we're taking that to mean that was a discharger notified that it was obligated to submit these quarterly reports? And then our examples are all the written documents and the communications between the time periods.
The prosecution team realizes that this is a large penalty, and we'd like you to know that we looked at all options to try and reduce it. As you've heard during the presentation, the facts of the case do not allow us to use the water code exception. We checked to see whether this discharger would meet the criteria to be able to use a penalty toward a compliance project, but they don't meet the criteria. We brainstormed other options with them during settlement negotiations, but none of them were acceptable. Unfortunately, our hands are tied and we're here before the board. But before I conclude, I'd like the board to know this penalty amount for this case was calculated in the same manner as we calculated several other mandatory minimum penalties that we recently issued to other dischargers who also failed to submit monitoring reports in a timely manner. Those dischargers have paid their penalties and their cases have been settled. To summarize, the prosecution team is recommending a mandatory penalty of $210,000. This ends my presentation. I'd like to enter the presentation and agenda material into the record, and we can answer any questions you might have.
Thank you, Wendy. Any further questions by board members? Does the prosecution, does the California Sprouts wish to cross-examine? No. Thank you. We'll take testimony then from California Sprouts.
And then I have a PowerPoint. Yeah, I don't even know how to start, where to find. So I gave it to him this morning, yes. I know that they had it to load, so. Oh, that would be easy for your presentations. Yep, California Sprouts. I believe that one's ours. Might be mine. Nope, that one's yours. Okay. We just saw that one. Oh, it's on the date. I had it the date, 12/5. There we go.
It's easier to use the up and down arrows.
Perfect. Great. Thank you. Tess Dunham with Somax Simmons and Dunn here today representing California Sprouts. And we appreciate the presentation. And as alluded to by the prosecution team and suggested by the chairman, we do take a different interpretation of the statute that is with respect to the potential exception application that you could provide. And we're going to hopefully encourage you to take that alternative interpretation today. And we're going to tell you a little bit about our company and what this penalty will mean to this company. So, and with this, so just to give a brief outline of our case here today, we're going to provide you an opening. Then we're going to provide you a brief background of events so you have some understanding about Mr. Shaw and the company and what's been going on. Mr. Shaw will then provide some testimony of his own. We will make a presentation of our legal and policy arguments, and then, of course, a closing statement. And I think as we all recognize, it's really important that we understand that what we're looking at here today is a $210,000 fine for pieces of paper. And there is no threat to water quality. There were no effluent limit violations. And you could tell, you've seen me a lot, and you've never seen me this emotional before you. So here, just so you know, is a picture of their products. They grow mung bean sprouts. So if you have bean sprouts on your salad, it may be one of their products. Some facts about us. We are 2 facilities here in Sacramento. One of them is called Pacific Coast Sprout Farms, and that's the facility that is subject to this ACL. There are a total of 27 employees at this company. 12 of them are located at this facility. Their major products are the mung sprouts that we just showed a picture of that are grown at this facility, and then at the other facility there are alfalfa sprouts and broccoli sprouts and radish sprouts and all kinds of sprouts that you can imagine. And the reason why it's important to realize that this penalty will impact not just the one facility, but it will impact the viability of both facilities. So let's talk a little bit about the growing process with sprouts, so you understand when we say it's a clean discharge. It's hydroponic based. It's water. It's water in a big warehouse, or bins in big warehouses with sprinkler systems in the roof. It's not outside. They have extremely stringent food safety standards that Mr. Scholl is going to talk a little bit about how they are a leader in the food industry with respect to their safety standards. They take sanitized seeds. They're planted in bins. They have a continual spray cycle for 1.5 hours, followed by a rest period of 1.5 hours. And it's this processed water that is then discharged to the storm drain system. It's a very clean run through. It's groundwater used for the bean sprout growing process that it is then discharged. It's a very clean process, very clean water. So Wendy gave an overview of the background of events, and we're going to provide, just a little bit more specificity to some of that. They were originally subject to the individual NPDES permit. They did become subject to the limited threat order on June 7th of 2012, and a notice of applicability was issued on that 2012. So here we are looking at what has occurred under this limited threat order, not under the individual order that was in place prior to that. And yes, they were required to start submitting quarterly reports beginning on November 1, 2012. So, as Mr. Scholl has indicated in letters that he has submitted to the regional board, he actually did attempt to make some initial attempts under the new order to submit his reports, but he was doing it electronically through the CWIC system. And there was confusion that had been created because under the individual order, back in February, before he became subject to the new order, staff had advised them that he needed to learn electronic reporting and that electronic reporting was coming. He needed to take training, and so he attended this training. And then when the new order came along, there was no explanation to explain how, under a general order, you can't use CWICs like you could with an individual. So he went from his own permit to a general, and CWICs was no longer available, but it wasn't conveyed to him that CWICs wasn't available. After several failed attempts of trying to submit quarterly reports electronically, Mr. Scholl, he apologizes. He'll give you his comments on his own. He went forward with doing what he does for the rest of the day, which is run the company, right? He's the general manager, he's the human resource manager, he's the sales and marketing manager, and he's everything that a GM is in a small company, and this is just one of his responsibilities. So he, after several failed attempts, went forward, started running his business, and just, did not remember that he needed to file the quarterly reports. So there's events that lead to today. So quarterly reports were not filed under the new notice of applicability. Mr. Scholl then did receive an email on June 4th of this year regarding those late reports. He responded immediately, and he provided those reports to the regional board staff on June 9th, within 5 days after receiving the email notice. It wasn't a notice of violation, it was an electronic communication from a student aide or a scientific aide, basically, oh, where are your late reports? Oh my goodness, I forgot, oh yeah, and got it to them right away. He had been doing the monitoring, by the way. It was just the submittal of the reports. So then, following that, everybody thinks life is great. Mr. Scholl then received the notice of violation and draft record for assessing violations on July 25th. That is where he learned for the first time that his late reports could cost the company almost $300,000. Needless to say, Mr. Scholl was quite shocked and surprised and concerned, and started to determine what do they do, and that's when I was engaged to help provide some assistance to California Sprouts. We also had received another self-monitoring report review and notice of violation on the same day. We did respond to both of those in written format. They're part of the prosecution team's exhibits. But we will talk a little bit to show you why we don't believe that the notice obligation under the water code has been met, as explained by the regional board staff, but we'll talk about that in a little bit. So, as no surprise, our argument here today is that you should avail yourself of the exception that is obtained, that is available under the Water Code under 13385.1b. We have given some pretty extensive legal arguments in our opening brief with respect to applicability of new statutes, and that we believe the sunset provision can only operate prospectively under the law, including California Supreme Court case law. We believe that this is not a procedural law. Obviously, it's substantive. You're affecting the rights of people with the sunset provision, and therefore, under the California Supreme Court case law, it applies prospectively. The only time that retrospective application is given to laws is when there's clear legislative intent that should occur. That legislative intent is not here within this legislation. Further, we contend that there were no effluent violations. I believe the prosecution team agreed with that, as in the rebuttal brief, and we disagree with respect to the notice that they have contended occurred. We don't believe that notice does qualify as notice, and therefore we believe we do meet the exceptions under the meet the conditions under the exception in the Water Code. And with that, I'm going to have Mr. Shull's going to come up and give a statement, and then I will be back with the remainder.
Tess, before you leave, what kind of notice you contend would have been sufficient?
Notice of that there were late reports, like the June 3rd or the June 4th email that he received was clear notice that, hey, you've got these quarterly monitoring reports and they haven't been received. He responded immediately to that email. As we will show you, and we have copies and pictures of the notice that the regional board is relying on, it's very generic, it's very general. It's not specific notice as far as, oh, hey, where's your late quarterly monitoring report?
Thank you, Board. My name is Dan Scholl. I'm the General Manager of California Sprouts in Sacramento, California, and I have taken the oath. I began working at California Sprouts as its General Manager in March of 2010. When I moved from Minnesota with the express purpose to turn around a struggling business. The company had recently moved from Tracy to Sacramento into a new facility, and the company had also purchased Pacific Coast Sprout Farms. My responsibilities at California Sprouts include sales and marketing, operations, managing all HR issues, as well as building an industry-leading food safety program. My responsibilities also included the compliance with all appropriate laws and regulations. This includes financial obligations, taxes, permits, compliance to FDA and the California Department of Food and CDFA rules. I was also responsible for compliance with the individual NPDES permit when I first started. This was all new to me, and I worked with Mr. Lucio Orlena, Victor Vasquez, and Anand Mamidi at the Central Valley Water Quality Control Board to learn what needed to be done with this process. At the same time, we were working on being part of the limited threat permit rather than our individual permit. This also involved an attendance at the daily seminar to learn the SIQUIS system. Once the permit process was complete in May of 2012, at my operation, we set up protocols to capture all the new information outlined in the permit, and then I turned my focus to my other responsibilities of a failing and struggling business. I did attempt to submit the first or second report of the new limited threat permit electronically into the SIQUIS system, but it didn't work, and I must have just moved on with something. We continued to capture the relevant monitoring information, but simply forgot to submit the paperwork to the board. Excuse me. Once I was made aware of the missing reports on Wednesday, June 4th, I immediately compiled and submitted the information to Mr. Elena on Monday, June 9th. At this time, I was not aware of any potential civil liability that the missing report would cause to the business. It was only after receiving the notice of violation in July 14 that I was made aware of the extent of the financial penalties. I did not fully understand the severity of the mandatory minimum penalties or how they were calculated. If I was aware of the financial ramifications imposed by mandatory minimum penalties, or if I was informed of the missing reports anytime between May of 2012 or June of 2014, I would have immediately sent in the appropriate reports. Excuse me. I did receive notice that there was a change to the permit, but this was in the form of a form letter, which I read and kept on file with the permit. It did not inform me of the missed reports or deadlines for my specific permit. In hindsight, I should have been responsible and reviewed the permit, contacted the board about the missing reports. but we had the water ratings, and I was focused on other parts of my business. California Sprouts is a small business with 27 full-time employees. Many of them have worked for the company since it began in 1999. Sorry. We recognize by California, the FDA, as shown by their use of California Sprouts for training purposes, as a leader in the sprout industry and food safety. I personally have worked with organizations like the California Emergency Food Response Team to educate inspectors by inviting them into my facility and in learning about the processes of safe sprout production. I'm currently active on 2 different working groups, along with the FDA, the USDA, the Institute for Food Safety and Health at the University of Chicago, in helping to design and implement a system to improve sprout safety for the entire industry. 2014 will be the first year since 2008 where the company will actually show any profit. My team at California Sprouts has worked very hard and long to turn the business around. My owners have been very patient and supportive of our efforts. However, the substantial nature of this fine assessed against the business far exceeds the profit made by this year, leaves the owners no choice but to close the business. As a result, the employees, including myself, will lose our jobs. I understand that the issue today involves the submittal of reports by appropriate deadlines. I have received a detailed outline of the report submittal deadlines, outlining the mandatory minimum penalties, and have developed and implemented the necessary procedures to ensure that we are in compliance with the system, with the permit, and submit the reports with the cover letter in the new electronic mail system. I am truly regretful that my oversight has caused this issue to become so complex and extreme. I understand the severity of the issue, and we have taken all necessary actions to ensure that we are filing our reports in the manner with which the permit outlines. Thank you.
Thank you. Is that, do you have further testimony?
Yes, we do. We have a couple of things that we'll run through. So I want to bring just to light here on this next slide that there were a couple of statements of error in the prosecution team's rebuttal brief that we wanted to identify. I did have the opportunity to give a heads up and share these with Ms. Draband prior to the hearing today. We had plenty of time while we were in the audience. So the first issue is that on page 5, lines 8 through 9, it states that coverage began on February 24th, 2012. That is an incorrect statement. Coverage began, while the NOA was issued in May, coverage began on June 7th, 2012. On page 12, lines 2 through 3, it states that there was a subsequent...
Yes, before you leave that one.
Yeah.
Began on February 24th, 2012. And I want to find out, is this in the order itself that you're talking about?
Is what in the order?
You say page 5. Page 5 of
That is, I'm sorry, that is at the prosecution's rebuttal brief.
in their rebuttal brief.
Yes,
Okay.
my apologies. I should have clarified. So, so it's in their rebuttal brief. We're just calling out some errors and statements that were made that were incorrect in the rebuttal brief.
That's what you say at the top. Okay, go ahead.
On page 12, lines 2 through 3 of the rebuttal brief, it says, it makes reference to a subsequent email that was issued after the NOA. We know of no said email. The only email we're aware of is this February 24th email, which was obviously issued 3 to 4 months prior to the issuance of the notice of applicability. Therefore, it was an email more directly related to coverage when they are under the individual permit and is not applicable to coverage under the limited permit.
Excuse me for interrupting you, but we'll be coming back to this. I'm sure I'd just soon cover it at this time. Do you have that email? I'm addressing my comments to the prosecution team.
Sorry, I'm looking to see what we're referring to. And Laura, if you had talked to Tess previously this morning about this, maybe you could respond.
This is Laura Drabant for the record. Are you referring to the subsequent language?
Yes.
Email after issuance of the notice of applicability? I would contend that the brief is technically correct, but clearly confusing. The email was sent after the application for coverage. It was not sent after coverage took effect. So my point in the brief was to say efforts were made to prevent violations from occurring before the report was due.
And your reply?
I think my reply is then, so the email was the February 24th email, is that correct? And the February 24th email was clearly issued prior to the notice of applicability and coverage under the limited order.
And I agree with that statement.
Thank you.
Thank you.
Continue.
And the third error is one that actually is referenced in footnote 1 on page 4 of the rebuttal brief, indicating that the California Sprouts had not followed through in submitting timely reports even after the June 4th, 2014 email. And we provided, and it was accepted into the record by a ruling by the chair, that we did submit that report on August 1st on its due date electronically, and we provided the email cover showing that it was submitted timely. Okay.
Thank you.
So can I ask a clarifying question in response to this particular slide? I'm trying to figure out whether these purported statements of error in the prosecution team's rebuttal brief, to the extent that may affect any findings in the proposed order. I'd seen some previous submittals where there was some agreement to make some changes to the proposed order, I think, in response to an inquiry that Cal Sprouts has made. I'm just trying to figure out whether, in fact, you guys are putting forward some additional changes to findings that specifically need to be made in the proposed order, or whether this is just a correction in your eyes to help the board orient themselves as to the chronology of events and what happened.
For me, it would just be I believe it's the latter correction.
Thank you. Thanks.
For
That's what I
orientation.
thought. Thank you.
Okay, so we're in responding to the prosecution's case. You know, we are going to talk a little bit here about what we consider to be notice or not to receive notice, or a lack of notice, I guess, in our case. We're going to talk about what that the communication that did occur in the intervening time period to when the notice of applicability was issued in May of 2012 and the June 4th, 2014 email. That's the time period where I would contend that we're looking at to determine, did the discharger receive notice with respect to the late reports. I'm also going to talk a little bit, Mr. Shull touched upon it, as far as, you know, whether there's really true notices to the impact of mandatory minimum penalties and how they would be calculated for late reports. And we will provide a little bit of more discussion on the sunset provisions, although I think they've been covered, you know, our positions without getting into a big, long, drawn-out legal argument with case law, right, Carmen? And then, of course, the fact that these violations and penalties continue to accrue for a significant period of time. And, you know, how does that happen? How does 2.5 years go by with a discharger being allowed to accrue penalties on this type of a basis?
Tess, are you going to have your client testify as to notice?
Well, he kind of made, he had not, you know, he's made the statements, he's made statements within the written submittals that we have.
I saw that. It's
So,
just for the record, thanks.
So one of the comments from the prosecution team is that this February 24th email, which was really about electronic submittal, had provided this initial notice, and we have contend, of course, that email was sent long prior to the notice of applicability. It applied greatly in large part to the individual permit, and in fact, of course, as we learned at our meeting in August, general order people do not submit their data through the CMIX electronic system. And we did not know that till we were sitting in a meeting in August with the regional board staff. And of course that, you know, there was really no communication with respect to this issue. You know, the regional board staff or the prosecution team, I'm sure, would say, well, this email that we're talking about, this February 24th email says, don't stop submitting your paper, which, okay, yes, it does say that, but there was great confusion when CWIX was first coming in, having worked obviously with lots of other dischargers as to what can be done electronically, what can't. And so we think that just added to the confusion as to what Mr. Shull's responsibilities were. I want to also draw your attention to, with respect to what does the notice of applicability itself state with regarding the method of submittal. It does not say whether all, monitoring should be submitted by paper. It just says they shall be submitted, which will include monitoring required as of the effective date of this notice of applicability. They must be submitted until your coverage is formally terminated in accordance with the limited general order, even if there is no discharge or receiving water flow during the reporting quarter. Nothing in here states that it should be submitted by paper or to the regional board staff specifically, and that electronic reporting is not available for the general order. Then, of course, there is these claims that Mr. Scholl had specific notice of reporting requirements. We're going to talk a little bit more about those. We contend that the only notice he had was that paragraph in the notice of applicability that he would need to submit the quarterly monitoring reports. The notices that they talk about, these 8 different notices or whatever, they are very generalized regarding the renewal of the limited threat order. They are not specific notice. There is a notice of automatic enrollment in new limited threat orders. Again, that's not specific notice as to with respect to the discharge monitoring reports and the fact that he had reports that were submitted late or that were late. Where are they? Come on, Also, there is reference to adoption of amendments to the limited threat order that occurred on June 6th of 2014. It's not relevant here. He received the email from staff with respect to his late reports on June 4th, 2014. We don't think that notice even would count. Plus, that notice basically was a link to a draft order with red line changes, which you know how long your orders are. Mr. Scholl's a general manager. He doesn't live in the sick little world that we all live in. So we don't contend that as being proper notice either. So I don't know how easy these are to read, but I just put them up here. I've got the prosecution team's exhibit number just to give you an idea. This is the notice that they are referring to that they contend was proper notice and disqualifies us from the exception under the water code. And this is a notice of public hearing for proposed waste discharge requirements. This is not notice of late reports or proper notice of Mr. Scholl, please submit your quarterly monitoring reports. The next one is the notice of adoption that went to everybody covered by the limited threat general order. Again, this is general notice saying, hey, look, we adopted it, and if you need to change your notice of applicability, please contact these people. The monitoring paragraph is on that page 2 in the middle. It says all monitoring reports, technical reports, and questions regarding compliance and enforcement should be directed to the staff below. That was the notice that they are referring to, which they say no longer qualifies us for the exception under the water code. The next notice is addressed to Mr. Scholl. I'm sure his name was replaced by everybody else's in each letter that was received, saying that you have been automatically enrolled into the new limited threat order as it's been revised. But again, it's pretty much the same paragraph as the last notice. If you have any questions, please contact this person. It's not specific notice with respect to the quarterly monitoring reports. With respect to the general understanding of what it means on MMP statutes and mandatory minimum penalties and how it's calculated and the potential impact, clearly, had Mr. Scholl known, MMPs, what it means for every 30 days late, which it's never been said anywhere in any of the notices that have been provided to him until the July 25th notice of violation, Mr. Scholl may have kept it more on his mind that these needed to be submitted on time. There's no statement anywhere regarding accrual of penalties for every 30 days late. All correspondence that we received after the notice of applicability was generalized. There was no notice regarding the late reports until June 4th of 2014. And I will include some of the examples that the prosecution included in their exhibits. No other discharger that has received mandatory minimum penalties, as I can see from what has been provided to us, are as impacted as California Sprouts. And we've got a table of the other MMPs that were assessed. So first, this is what the NOA says with respect to MMPs. Failure to comply with the limited threat general order may result in enforcement actions, which could include civil liability. Effluent limitation violations are mandatory, subject to mandatory minimum penalty of $3,000 per violation. In addition, late monitoring reports may be subject to MMPs. I don't think that statement hardly puts people on notice that they should understand what a mandatory minimum penalty is and what the liability could mean and accrue to them. The prosecution team included a number of examples of other MMPs that they've issued under low threat and limited threat orders. Here are the, I think, 4 that I pulled out from their exhibits. And what you can see is that the San Francisco Public Utilities Commission, the date of their NOV was July 26th. The amount assessed was $51,000. They did apply the exception to 3 of their reports. Some of that cost here is because they had effluent limit violations in the total of $51,000. So yes, they received a fine, but again, they did get to use the exception because their NOV was issued in 2012. The city of Placerville was issued one for late reports. They did not receive the exception because they didn't conduct any monitoring, but because it had only been a few months since the reports were due, their whole amount assessed was $18,000. Ramus Homes, here in 2014, had some late reports, but again, because the review of the file must have occurred much more timely for them, the amount assessed for them is $9,000, and then McIlvaney was the highest at $57,000. Clearly, $210,000 versus the highest here of $57,000 is a significant different impact. And I think, I don't know, and I'm not saying anything other than I think it's interesting that there seems to be this every other year review for these low threat, limited threat orders. We have NOVs in 2012, and then we have NOVs now again in 2014, so I don't know if anything happens in 2013 or not. We believe that the sunset provision cannot be applied in the way that the prosecution team proposes. Otherwise, the statute would have had no real legal effect. Regional boards could have just waited until January 2nd, and no exception would have ever been allowed in the 3-year time period that the statute was available. Legal effect should be of the conduct should be assessed under the law that existed when the conduct took place. That is what the California Supreme Court has said. New statutes, which the sunset provision I contend is analogous to a new statute, and by the way, we looked and there's no specific case law on sunset provisions, but new statutes operate prospectively unless the legislative intent clearly indicates otherwise. There is nothing in the statute that says that the exception should not apply to violations that occurred prior to the sunset date. And there's no legislative intent indicating, well, that's what I just said, sorry. So we believe you can apply the 13385.1B exception here. Impact of this penalty. California Sprouts is a small company. As Mr. Scholl testified, there are minimal profits this year, not sufficient to cover the cost of the penalty. The owners have indicated to him and to me in conversations that they will be forced to close the business, and all employees, including Mr. Scholl, will become unemployed upon the assessment of the penalty. So in closing, the conditions of 13385.1B have been satisfied for violations that occurred prior to January 1, 2014. 5 quarterly reports should be assessed at $3,000 per report, not for every 30 days late. 2 quarterly reports that were due after January 1, 2014, we would agree should be assessed under 13385.1A. Those all put together would be a total penalty of $30,000, applying the exception to those that were due prior to January 1, 2014. We are really asking you that it's exceedingly important for you to look closely at the legislative interpretation and to apply this section accordingly. Like I said, I've never had a case that's hit this close and personal before. So, and again, there's no harm to water quality. And actually, just one more quick comment. I think one of the prosecution team members said it, that was this a discretionary penalty? You would be able to consider the impact to having a business go out of business in assessing that penalty. How is it that the mandatory minimum penalty could be applied so constructively narrowly that that isn't taken into consideration. We do think you have the ability to interpret the statute in the way that we've provided, and that would allow California Sprouts to remain a viable company. Thank you.
Thank you. Questions from board members?
No, I've looked through the declarations. I would like to ask Mr. Scholl if you had been on specific notice that these reports were pending, would you have submitted them?
Yes, of course I would have.
Yes, you showed one slide with 4 penalties for other cases. I'd like to go to the slide before that.
This one?
That's right. This is your statement regarding enforcement in,
This paragraph comes from the notice of applicability that was issued in May of 2012. It's prosecution exhibit. I even wrote it down on my thing, so I had it because I thought.
Exhibit 15, page 4.
Yes, thank you.
okay, and I find interesting the last sentence there. So this is the notice of applicability, and this states that in addition, late monitoring reports may be, and that sure sounds discretionary to me.
And that's how Mr. Scholl read it as well.
Very good. At this point in time, then I'd like to ask the prosecution team, do you wish to cross-examine?
No cross-examine.
Thank you. Are there any interested parties? I don't have cards for any.
Dr. Longley, we would like to close.
Well, we'll close, but I have to just check. I have to make absolutely certain that I know most people out there, they're interested, but they're not interested parties in the sense of this issue. So we'll have, at this time, a closing statement by California Sprouts.
Thank you, Dr. Longley. We are asking you today to do the right thing. Interpret the water code and allow the exception to be applied, and understand that I don't consider generalized notice to be notice as it was intended under the water code. So we believe we have met the conditions under the section of the statute, and we also believe legally not only can you, but must allow violations that occurred prior to January 1, 2014 be allowed to be considered under the exception. So with that, we ask that you reduce the penalty to $30,000. Thank you.
Thank you. Closing statement by prosecution team.
Thank you. I have a few points in response to Ms. Dunham and Mr. Scholl's discussion, and then Mr. Altovoigt will finish our closing for us. First, it's interesting that Ms. Dunham was using the phrase specific notice. That's another term that's not in the statute. The statute reads, a notice of the obligation to file a discharge monitoring report required pursuant to section 13385 in connection with its corresponding waste discharge requirements. It doesn't say specific, it doesn't say actual, it doesn't really define it. Secondly, I too wanted to bring your attention to the notice of applicability, exhibit 15, page 4. The language there does talk about enforcement, does talk about all monitoring report submittals and questions shall be directed to Lucio Oriana. And it gives his email and his phone number, and later on, or in the permit itself, it gives the physical address. The language about, Dr. Longer, you pointed to the slide that's up on the screen right now. Late monitoring reports may be subject to MMPs. Keep in mind, that was before this exception expired. This exception expired January 1st of this year, so when this notice of applicability was written, this was still true. Finally, there's questions about whether Mr. Scholl addressed notice in his testimony, and I would contend that he did. When he made the statement, he simply forgot to mail the reports to the boards. He knew he had to mail those reports to the boards. Thank you, Mr. Altovoigt.
And I just wanted to finish by saying, I mean, we are very sympathetic to the situation faced by this discharger. I think we agree with much of what the discharger said about both the nature of their discharge and much what they said about their behavior. we just feel like we don't have an option under the law to reduce the penalty. And as I mentioned, I mean, I talked with numerous attorneys, in addition to Ms. Draybrandt in the Office of Enforcement. I talked with Mr. Kerrigan, the head of the Office of Enforcement, who, in fact, told me that it would violate his professional ethics to interpret the law in the way that's being suggested. I mean, we really did try to figure out a way that we could make this interpretation, and we were unable to do that. But you know, and so we feel very much constrained by the water code. That, you know, and that all said, our understanding is that the board would need to make several specific findings in order to reduce the penalty to $30,000. And with that,
Thank you. Close the hearing at this point. Conversation will be limited to board members and members of the advisory team. You know, personally, what I don't find compelling is the action of the board of notifying California Sprouts of the severity of this issue. In other words, a timely notification that you do have a problem. I do believe that Mr. Scholl was negligent. That doesn't excuse him from not reporting. But I just find the result that's coming out of this to be completely disproportionate to the violation itself. This was a report of this was programmed as a limited threat general order, and no harm to the environment. No, actually, no great potential for harm to the environment in this particular case. I did find compelling, regardless of the statement attributed to Mr. Kerrigan, that the January 1, 2014 exception could be applied here. We would have to find that that the statute was substantial, not procedural, as I understand. And certainly, I think that it was that. I don't find the language that is very, very specific to, despite what I've been hearing from the prosecution team, that this is as steadfast a date as they contend it is. And then this last statement just bothers me. In addition, late monitoring reports may be subject. May is not absolute, I'm sorry. You may jump off the bridge, you may not jump off the bridge. It just doesn't, it's not convincing to me. Any other comments?
Well, I'll say that I think what I've heard about notice is that there's notice about whether or not Scholl knew about the responsibility of needing to file. That's one kind of notice. And the other kind of notice is, you know, was the company on notice that their reports were late? And that's the difference that I see on this issue. I tend to fall more on the side of the discharger. As far as, you know, the legal argument that Ms. Dunham made about the way the statutes are read, you know, I didn't research a specific statute, but I can represent that, you know, from the work that I do and since I was in law school, it's very clear and it's sort of generally understood that unless the legislature specifically says that this is intended, that a statute going forward is intended to be retroactive, it has to be explicitly written in there. And if it's not, you can't make that interpretation. So that's number one. Number two, you know, the law in case law says that the legislature knows how to define what they want. And if they want something to be retroactive, it has to be explicit. And anything short than that, you can't imply that intent. So, you know, I would feel comfortable making those findings a fact. I think that I'm sympathetic, certainly, but the law is what it is, and I can see why the prosecution team is limited, because they're findings of fact and legal issues that they can't make. And so, in my opinion, sitting up here, considering equity and the findings of fact, I feel comfortable agreeing with what the chair has said.
Bob?
I think staff did exactly what staff needs to do in the position they're in. But what I find compelling is that I think everybody in this room feels that this is not a fair action. And I'm going to...
They can't hear it, Bob, for some reason.
What I find compelling here is that it appears to me that everyone in this room feels this is not a fair action. And I'm going to take that into serious consideration as I make my vote.
Yeah, I agree with Bob that, staff has to do what they need to do. And I understand and I appreciate staff for doing what they need to do. However, I don't feel this is a fair action, and I think that they did the reporting. They found no evidence of discharge. They unfortunately did not submit them. However, it clearly states in the order that they may be imposed penalties. There was no notice that they had ever not submitted reports and the implications for that, and I just don't think it is appropriate to be assessing any sort of penalties based on essential lack of knowledge based on the discharger. So I would be inclined to go with the discharger's proposal of the $30,000 penalty.
Dr. Longley, if I could just make a quick comment.
Sure.
I guess just based on the comments that I've heard from board members, if board members are, if they may seem inclined to adopt an administrative civil liability in the amount of $30,000, we'd like to, although I hear the computers are down, they may be up, but we'd like to take a quick recess and see what we could do to put some findings together that we think are not only make good public policy, what I'm hearing in terms of the board's concerns, but also as it pertains to the legal issues. I respectfully disagree that there isn't at least some discretion on behalf of the board in terms of how it chooses to enforce the particular notice provision in order to evaluate whether in fact Sprouts can take advantage of that particular defense. And I also think that yes, the statute 1335.1B4 does specifically say that this subdivision shall become inoperative on January 1st, 2014, but what does that really mean? And if...
Well, let me ask you this question,
Sure.
Mr. Coop.
Sure.
I think both of those issues were addressed by Board Member Ramirez. Do you agree with Board Member Ramirez's comments?
I don't think...
I know.
As far as general black letter law principles are concerned, yes. But I want to caveat that by saying that I didn't find the briefing on either side as it pertained to, prospective versus retroactive liability to be particularly illuminating in pushing the board in one direction versus another direction. But related on that issue, I think if I read the prosecution team's papers correctly, I read something to the effect that it wouldn't really matter when we chose to bring the particular action. It's really, for purposes of the sunset date, it's really assessment that matters as opposed to when the violations occurred. And I do think that raises some interesting public policy and due process concerns, arguably, that the board may have. If we're to adopt the prosecution team's logic that in this particular case that the defense doesn't apply just because we chose to assess the liability after the time that arguably the provision sunsetted, then I find that very problematic. The prosecution team could have waited 5 years, 10 years, and decided to issue an administrative, theoretically, and would have racked the fine up much, much, much more significantly as a result. I do think that there's at least some flexibility in the statute to at least, again, on public policy, and I think just basic fundamental due process concerns that the board needs to think seriously about this provision in the context of when the specific violations occurred, which I think is the balance that that Ms. Dunham was trying to strike, and the violations that occurred after January 1st, 2014, where they did come forward and say, no, we're not going to extend the argument quite that far. We're only going to say that the defense applies prior to January 1st, 2014, but not after January 1st, 2014, which allowed them to come to the $30,000 penalty.
Denise, did you wish to speak?
Just a brief comment. I mean, I'm new to this, but this is the second time today I've heard where a company, because of an oversight or something, is here before the board. And if that oversight had not occurred, you would not be here before the board. So I'm not in disagreement with the position that the board members have taken, but there's responsibility here for the board, and the staff has a duty, and there's compliance issues with Sprout, California Sprout, and that's the reason you're here. So while I understand, and I understand the small business, I really do understand that part, you're here for a reason, and it's because there was something that was oversight on your part. That's not the responsibility of the board nor the responsibility of staff. Their duty is to make you be in compliance. That's all my comments.
Thank you. Carmen, I need to get my head on straight here. I hear counsel saying one thing and you saying something. I want to make sure. Could you reply to what David said?
Well, he said so much. I remember he said he agreed with me, so that's what I remember.
Sticking with that part.
I kind of turned off after that too, but
that's when I stopped listening. No, no, I agree. I think that's a serious policy issue. I think that in my preparation, I saw something where staff also has a duty to not delay, or I don't remember what the term was, but to bring things relatively quickly. And I think that delay, and people not knowing about penalties that may apply, certainly, does have the potential of becoming something that's unethically high. So the danger's there.
And just to follow up on Board Member Ramirez's comments, and this was an issue that wasn't specifically briefed by any of the parties. There's some specific language, I believe, in the enforcement policy as it pertains to the assessment of mandatory minimum penalties. On page 23 of the enforcement policy, it says, quote, "The water boards shall expedite MMP issuance if A, the discharger qualifies as a small community with a financial hardship," we recognize that exception does not apply, or the total proposed mandatory penalty amount is $30,000 or more. I think the board has a certain amount of discretion in interpreting the enforcement policy to evaluate what does the phrase "shall expedite" mean in this particular context. We're talking about certain violations that I think at least stretch back to maybe the late of 2012, and we didn't see an ACL complaint until, I believe, September of 2014. Whether, in fact, the board thinks that's consistent with the enforcement policy is for the board to evaluate and decide, but I just wanted to highlight that language for you.
That's language I was referring to, so thank you.
I am going to continue this item to give you an opportunity to prepare findings. We'll go back to item 24. And I find I have to give a few minutes for attorneys to change seats. So we'll have about 3 or 4 minutes here while we let the attorneys change their seats.
Can I change my seat?
so I can present a redline version of the order.
Okay.
Attachment G, which is the methodology, which has the changes that they wanted to make. I just have the changes tagged out, so I'm going to refer to those changes as they refer to their hard copies, and we'll have the changes.
And Patrick knows what it's all about.
Yeah,
Yeah, okay, all right.
So-
Yeah, I did.
It's all we could do. I mean, the computers just went down like at the wrong time. Fortunately, we were able to, yeah.
Patrick, are you ready? Okay. Okay. Is limited to the advisory team and board members, and you were going to work on the amount and on the findings.
Yeah, and I have to say, I instructed the
Like, can we be clear on what agenda item we're talking about? Just because now you guys are coming back with Slate, and we just got done with Sprout, so just
Sprout, you've been continued on Sprouts to after we
Thank
finish
you.
Slate.
Thank you.
Okay.
reopening the Slate ACL
That's right.
item. The modifications are primarily to Attachment G, since Attachment G is referenced as the penalty calculation in the order. And scrolling down, you'll see most everything remains the same. There is a finding that was changed, and though the prosecution team get the first cut at these, I actually, this is correct. Just checking versions. Our network was down. Though the prosecution team did the first cut at these, they turned them over to me, and I incorporated them into this document with maybe one very, very minor change. This adds this sentence that says, furthermore, the discharger has exhibited complete defiance of the board's directives regarding the irrigated lands regulatory program, which harms the program. That's again to justify the 0.4 to 0.7 increase. Going down a little further, the 0.4, it's changed to the 0.7. Scrolling down a little further, we have this statement is added, applying, and this is regards to reducing the number of days, applying this assessment method on the total of 320 days of violation days gives the board the discretion to reduce the assessed penalty days to a minimum number of 16 days based on the discharger's defiance of the irrigated lands regulatory program and the overall threat to the environment and to the regulatory program. The board finds that it is appropriate to only decrease the assessed penalty days to 32, essentially a double from the minimum. And then that changes the final liability assessment amount to $32,032, and that's changed throughout there. And let me see if I can find the other one. Okay, here's the order. The order, again, does not have many modifications. Finding 17 just adds an as modified to very much clarify that attachment G was modified. Scrolling further down, the only other change is to the change to the penalty assessment amount. And that's it.
Very good. So I entertain a motion to accept this order
I so move with the revisions.
and the late revisions, yeah. Do I have a second? It's been moved and seconded. Is there any further discussion? Okay. Call the roll. And this is pertaining to the Slate item.
Mr. Snyder? Ms. Ramirez? Yes. Ms. Moffett? Aye. Ms. Kadara?
Yes.
Dr. Longley?
Aye.
Motion carries.
Very good. We'll move now, we finished that motion. We will take up once again the Sprouts motion, issue, which is item 25.
So Dr. Longley, before council speaks to you about the changes he's recommending, Ms. Kadara made some comments. I want to thank her for making comments regarding the discharger, and I really appreciate that from the board. I just want to point out, though, so the board remembers, the discharger is not saying they shouldn't be penalized. The issue is really around whether it should be based on the old calculation of how you establish MMPs versus what the prosecution's been alleged they have to do. So it's not about whether they should or should not be penalized, it's just the amount.
Thank you for that clarification, and I think it was made clear early on that if the amount was to be less, it would be $30,000.
And I just want to reiterate that this board, I think everybody said or expressed that deeply appreciate staff's work on this, and I think this is one was particularly difficult, and this one where the board has their job to do, and it's, you know, the staff has their job that they need to do, and it's not always easy, and the board's allowed a little more, or it will take a little more discretion that we can. So I think that's why the board works well, as we have those elements.
Very good. We're ready, David.
Okay, based on the direction that we got from comments from board members during the hearing, the advisory team has some suggested proposed changes to the order. There is a lot of red in here, but the changes really aren't as large as you may think. I'm going to walk through them quickly. I would suggest to solicit, maybe provide a few minutes to provide some review and feedback from the parties, given the lateness of the changes that are coming in response to board member comments. But let me walk through the changes really quickly. The first substantive change, we're talking about finding 7, as noted here. The previous version of the order said that that the discharger had been notified of its obligation to submit monitoring reports, and that 1335.1b does not apply. Based on comments that I heard from the board as to notice, we've stricken that particular provision. The next comment in finding, we made a new paragraph 11, finding 11, to just lay out the law as it pertains to the applicability of the particular notice provision. And just for purposes of refreshing the board's recollection, and we're really focusing in on the language in, if you can see where my cursor is, where it said, well, I'm gonna move it over there. So if you look at that line right there, we're talking about under A, the discharger did not on any occasion previously receive from the state board or regional board a complaint to impose liability pursuant to subdivision B or C of section 13385 arising from a failure to timely file a discharge monitoring report. And then for purposes of this proceeding, quote, or a notice of the obligation to file a discharge monitoring report required pursuant to section 13383 in connection with its corresponding waste discharge requirements. I think that's very important language for purposes of the decision that the board's being asked to make today. And I think to help further elucidate comments that I heard from board members about the concern about making a distinction between generalized notice and a more particularized form of notice. The next finding, probably inelegantly, makes an effort to try and apply the facts to the law, and I'm just going to read through that really quickly for purposes of the record. Finding 12, as it reads, says,
Quote, in this case, the discharger did not receive written notice of the obligation to file any of the 7 discharge monitoring reports in connection with its corresponding waste discharge requirements as referenced in attachment A for the 3rd quarter of 2012 through the 1st quarter of 2014 until staff's email to Mr. Scholl on June 4th, 2014. And then I referenced the specific prosecution team exhibit. In response, the discharger filed all 7 discharge monitoring reports within 30 days after the discharger received written notice pursuant to regional board staff's email of June 4th, 2014. I cite that particular exhibit. As a result, the discharger did not receive a complaint, and I walk through the fact that the discharger did not get adequate notices provided by regional board staff for purposes of the ability to apply this particular defense. I also wanted to specifically point out that there were no effluent limitation violations reported in the 7 discharge monitoring reports. There wasn't any disagreement on this particular issue, but it's important for demonstrating the applicability of the defense under 13385.1 B1 and B2. The next finding, and finding 13, has to do with the particular sunset provision in this particular case and its applicability or inapplicability as it pertains to this particular action. And I'm just going to read through that really quickly. It says, quote, the provisions of Water Code Section 13385.1 B1 and B2 apply to violations that occurred prior to January 1, 2014. I probably might want to modify that to say in this particular case. We're not necessarily making a judgment call as it pertains to other matters that the board may consider, but certainly we're talking about this in this particular case. The finding goes on to read, quote, this interpretation is consistent with the legislative history to make the provisions pertaining to reporting violations more equitable, citing to the legislative history in Exhibit D that was provided by Cal Sprouts, and a plain reading of Water Code Section 13385.1 that does not preclude the ability to assess MMP violations as of the time that the violation occurred. I think that's an important due process consideration, as I mentioned earlier. Quote, in addition, assessing MMPs for violations that occurred prior to January 1st, 2014, pursuant to Water Code Section 13385.1 B1 is consistent with pertinent language in the State Water Board's enforcement policy, noting that, quote, the water boards shall expedite MMP issuance if the total proposed mandatory penalty amount is $30,000 or more. Then I go on to say, quote, the board further finds in this particular case that not assessing mandatory minimum penalties until an administrative civil liability complaint was issued on 8 September 2014 does not result in expediting the issuance of MMPs as required by the State Water Board's enforcement policy, and would frustrate the legislative intent of Water Code Section 13385.1B, which is the defense that the board wants to recognize in this case, as demonstrated in the legislative history in Senate Bill 1284, and again, citing the Exhibit D legislative history materials. Then I go on to talk about the findings themselves and making a distinction between the ones that occurred prior to January 1st, 2014, and those that occurred after January 1st, 2014. Finding 14 talks about the 5 late discharge monitoring reports that were late prior to when the violations occurred on January 1, 2014, and that allows the board to use the defense in order to assess liability on a one-time basis of $3,000. And so for those particular 5 discharge monitoring report violations, that results in a total of $15,000. And this is just, I'm cutting this because, again, these previous findings are premised on the fact that the 13385.1B defense can't apply, and that therefore the board has to assess liability under 13385.1A. The direction I heard from the board is they're not willing to adopt findings to that effect. The next finding, And I'm going to make sure this is numbered, the paragraphs are numbered correctly. I don't think the paragraphs are necessarily numbered correctly here. It says 11 here. I think it should be 15. We can renumber that. But the next paragraph adds the provision to make clear in discussing the two violations that occurred after January 1st, 2014, and recognizing that the defense does not apply, the 13385.1b defense does not apply to violations that occurred after January 1st, 2014. And that's how we come up with assessing the liability under 13385.1a, which allows for a mandatory minimum penalty of $3,000 for each 30-day period it's late. And that allows us to come up with the $12,000 figure there. And then pertaining to the first quarter 2014 self-monitoring report, there was only one 30-day period in which it was late, as assessed under 13385.1a. And so we're looking at an amount of $3,000. That gives us a proposed amount of $30,000 for purposes of administrative civil liability. It's listed here as paragraph 15, but I think it's actually paragraph 19. We'll just need to throw in the date as to when the board adopted the order, assuming they choose to adopt the order today. Again, reflecting the amount of $30,000 here as opposed to $210,000. The same with this portion, this paragraph here. I wanted to add this provision. There wasn't much discussion of it in the context of the hearing, but the ability to use the defense is premised on the fact that the discharger, in fact, pays the administrative civil liability within 30 days of issuance of the order. So I just wanted to make it, and I'll read through that. It just says, quote, the failure by Cal Sprouts LLC to pay the administrative civil liability of $30,000 pursuant to this order within 30 days of issuance of this order constitutes a failure to comply with this order and a failure to comply with Water Code Section 13385.1 B2B. Again, that's just putting the discharger on notice of the fact that despite the fact that we're recognizing the notice defense in this case, if they don't pay the liability within 30 days of the time that the board issues the order, we got a problem. Again, I need to throw in the date, assuming the board's inclined to adopt the order. I've made some suggested changes in response to attachment A. Instead of calculating the number of 30-day periods late under 13385.1a, we're assessing them under 13385.1b and saying that the defense does apply. So you're seeing a total of 1, 2, 3, 4, 5, a total of 10 violations. Or excuse me, yes, 5 violations total. Excuse me, 10 violations total of 7 self-monitoring reports, 5 violations being subject to MMPs under 13385.1b, and using that defense and saying it's applicable in this context, and 5 violations for in response to the 2 self-monitoring reports that were violated after January 1st, 2014. That allows us to come to a total of 10 total violations and a proposed mandatory minimum penalty of $30,000.
Go back to bottom of page 6, please.
You bet. Yes.
Okay. Denise pointed out to me that number 1 at the bottom of this page in the amount of $200,000. $210,000. You need to do that needs to be $30,000 also.
My apologies. You're right. It's referenced as the number. It should say $30,000 instead of $210,000, expressed in its as
so
other than numerically. So yes, I will make sure that they hook up together. We're talking in this case about a proposed order that the board's going to assess in the amount of $30,000, not $210,000.
So the date of this order will be today's date?
Correct.
And the paragraphs, in fact, are not numbered correctly, but it goes, I think, opposite of what you stated. Okay. Regardless, I ask for a motion for what you see before you with the correct date inserted and with the paragraphs renumbered so that
Dr. Long, you might want,
subsequent.
it's certainly subject to your discretion, but you may want to allow for, input from, I'm pretty sure what the prosecution team's position is in response to the proposed order. I don't know if Cal Sprouts necessarily
I
has
think-
any
I think
changes,
we'll-
but I'll leave that to your discretion.
We'll go ahead with this.
I would make a motion that we approve the document for us, subject to the administrative changes, but the substantive findings would stay as they are.
And so by administrative changes, you're just talking about the renumbering of the paragraphs?
Yes, and the date.
And the date, right, okay.
Do I have a
And
second?
including the proposed late revision from Board Member Kadara.
Yes.
Thank you.
Yes. And do I have a second?
Second.
Board Member Kadara seconds. Any discussion? We'll call the roll.
Mr. Schneider? Ms. Ramirez? Ms. Moffett? Ms. Kadara?
Aye.
Dr. Longley?
Aye.
Motion carries.
Well, it sounds like the order's already been adopted, but what I did hear from prosecution team staff is that, that the CWIX numbers arguably may need to be updated. I don't think that's a sufficiently substantive
Well,
change.
Yeah, and I think that, excuse me, I have a cramp. I think that we have the issue that there needs to be an awful lot of education done out there. CWIX, there's a lot of confusion on how to report and so on and so forth. It was mentioned that this is the only one we've had like this, but I've heard a lot of complaints about using the systems and which one to report to, and it's a serious, whole data issue is a serious issue. So with that said, is there any other additions to the to what we're doing today? Anyone want to make any final comments before I close the meeting? We are adjourned until the next regular meeting, which will be the first week of February. Thank you.